We are in chapter 12, Georgia's Lies. We are going to just jump right in. When my daughter was 4 and beginning to understand what having been adopted meant, she reeled. She'd lost her place on earth. Whose tummy did I grow in? She demanded. Near panic. Was it Lynn's, Jean's, Susie, Kathy's, Cappy's? She named relatives, neighbors, friends. She seemed prepared to interrogate strangers, and by the fall of her sophomore year in college, she was ready to learn the answer to her question. I spent 19 years not knowing my birth mother. I don't want to spend more, she said. Okay, first of all, adoptees should never not know they're adopted. We should always know our story, but even then, as Barbara is talking about her own daughter, I will say I had a similar moment where I pretended to be birthed by my adoptive mom. I know it sounds weird, but that was just kind of what I needed at the time. Even though I knew the truth, my parents never hid anything. And I was in contact, which brings me to open adoptions are really important to the adoptee, right? With the adoption contract is what we call the PACA agreement, right? It's the post-adoption contact agreement. And with that, it is supposed to specify how contact is made, for how long, and kind of like what can be forth. Now, unfortunately, in the majority of states, PACA agreements are not legally binding, which sucks, right? We talk about this all the time. In the best interest of the child, majority of the time, I'm going to say like 97 to 99%, it is within the best interest of the child. Now, I say this as you should listen to what your adoptee wants. Not every adoptee will want to continue to have contact. It may be a day, it may be a month, it may be a couple years, and that is okay. Listen to your adoptee. And this goes for the birth parents with PACA agreements. Understand that adoptees are going to have that moment. It's not necessarily because of who you are, and it's not necessarily the adoptive parents, okay? We have to respect the adoptee. And this can happen at any given age. There are adoptees that are well into their adulthood who don't want to search, and that is perfectly okay. And then you have adoptees of varying ages who do want to search. They want to answer the lifelong question of who am I? Where do I come from? Why me? What, what's my culture? Who are these people, right? What's my medical information? And that's okay too. All right? Like both are okay. Not searching doesn't mean that you're in the fog. I want to make that clear. Some people have just decided that they don't want to search, and some people have searched and had a really bad time. Some people have searched and had a good time. Some people have had a mixed time, like me. It's not a one size fits all. Let me make that clear. And so this is why I always say listen to the adoptee. Not everyone will want the same things, and that is perfectly okay. But what I am going to say is that from now on, every adoptee should absolutely know that they are adopted from the day they are born. They should not remember the first time that they are told. They should know their story. And if you are an adoptive parent, say it without judgment. I was talking about this in the chapter before, right? Something that my adoptive parents have done is they never hid the truth from me. Always age appropriate, including things, the criminal records and the horrible things that my biological father and my older half-brother have done, but they always did it at age appropriate times, and they never cast judgment. Now I I can absolutely cast judgment. If you knew, like, if this wasn't biologically, like, I would completely understand that they would cast judgment. I understand my dad. My adoptive dad, he's the one that is really my dad. He said, if you want to meet them, that is one thing, but I would rather you didn't, just for your safety, right? If you are going to let us be there for you to make sure you are safe. Especially towards my biological father, right, and his side. Whereas with my biological mother, and I had this conversation with my mom, my adoptive mom, the other day, I don't remember her offering to take me to meet her when I was younger. But apparently I had really wanted to go, but I wanted to stay in the same house. I wanted to be in the same house as my bio mom. I wanted to be in the same house as my brother, my younger brother. And my mother said, no, we could go, but we're going to stay in, a separate place. We'll stay in a hotel. This way you can have a break. This way you just don't know what's going on. I honestly don't remember any of this, okay? I don't know how old I was, but I believe my mother did just this. And it just never panned out, right? I guess I had said, never mind, and we never did it. But that's what she had suggested. Looking back at that, I now understand my mother's sentiments of staying in a separate place. First of all, I need breaks from people, okay? Like, people are draining. But not only that, she was absolutely spot on. What if it didn't go well, right? What if there was just something about it, like safety first of all, not saying that my bio mom is unsafe, but like there was just things that like you just don't know, right? And I'm seeing on TikTok, birth parents reuniting with their children of varying ages and seeing the growth happen to the point where they are able to have, sleepovers, or they do vacations together, or, just there's different types of these PACA agreements, right? Or reunions. And everyone looks different, and that's okay, first of all. But I just want people to understand that, like, as an adoptee, we should always know our story. We should always have access to our story, and there should never be judgment casted upon our biological parents, even if they are horrible, by our caretakers, whether that's a guardian, kinship, fictive kin, adoptive parent, foster parent, whatever it may be. They could be the most horrible people. Do not cast judgment on them. Give the facts and move on. I understand you can have your emotions, but keep it to yourself. Okay, I know that sounds strange, but in the best interest of the child, keep it to yourself. Allow the child to lead. Now, in this paragraph that we just read, even though her child always knew, or at this time, like, her child knew, she said she finally understood, right, what it meant to be adopted, she had an identity crisis. We have those, right? And this isn't new. This isn't, like, even with open adoptions, right? We're going to have those questions of, first of all, did you lie to me? Why did you give me up? Why was I the only one? Who are my siblings? We're still going to have those questions, right? We may have some of the answers. We may not believe some of the answers. But we're going to want to know the information. Now, when I say we should always know, it is because late discovery adoptees, those that find out that they're adopted much later on, will not only have that same identity crisis at a much older age, they now no longer will trust you as your guardian because you then lied to them. You withheld the truth, or you lied, maybe you really did outlie. You got to tell them. Like, there's no two ways about it. You're breaking their human rights, but also you are blatantly lying to them. All right, continuing on. Finding her mother would have been difficult, maybe impossible, if Beth had been a typical American adoptee. Wait, what? Sorry. If Beth had been a typical American adoptee, since American adoptees are legally forbidden knowledge of their birth parents' names. In all 50 states, adoptees' birth certificate, which lists the children's birth names and the names of their birth mothers and often fathers, are sealed upon finalization of their adoptions. Their adoption records are also sealed. Adoptees are then issued false birth certificates that portray their adoptive parents as their birth parents. That is very true. I will also say in some places they will change the name, they will change the birth date, and sometimes they'll even change the location. Now, I will say on my original birth certificate, it does not list my biological father, even though I always knew who my biological father was. He actually signed the adoption papers. I have the information, I had the pictures, all of that. But he never actually was on the birth certificate, which it's kind of weird. It makes it more complicated for me later in life, for other reasons, but when mothers do this, right, either they're hiding their pregnancy because if you read The Girls Who Went Away, or because they don't want the father for whatever reason, DV, alcohol, drugs, whatever, or they don't actually know, it's easier for them to relinquish their child sometimes. That's a whole thing in itself that we have to go down the rabbit hole, but often birth fathers are not listed. Sometimes they are, but majority of the times they're not. And it just makes it easier. Now, I will say I did not list my ex on my son's birth certificate originally because of one of these scenarios, right? He very controlling, very narcissistic, and he himself, although he knew I was pregnant, and I was not, I was keeping my child. I was not going to relinquish. He had said at that time that he would willingly sign his rights away. Now, I want to make this clear. This is very different. Willingly sign your rights away when a mother and or father, whoever parent keeps their child, depending on the state, as long as it's a willing thing and not through foster care, can then get their rights reinstated. It's a little bit more complicated, but it is possible. And in New York State, if you do that, you can get your rights reinstated. If you file for child support, they will then force that in. They will then file for a custody agreement. I know it's very frustrating. You can file a custody agreement without child support, but you can't file a child support without a custody agreement. It's so annoying. Anyway, sorry guys. The fact, not only have I gone through this, I had a long discussion with the head of family court. She happened to be my aunt, so thank you, in my state. But I had this conversation before we had to even deal with court. So eventually he filed, and we've been going through that, and I will say it's a headache. But sorry, I'm going on a tangent. Anyway, what I am saying is that it's vastly different when we're talking about a single parent not placing the child on the birth certificate versus because of the adoption, right? Now, I will say that if a DNA test is done for the single parent for custody agreement, they will do a DNA test, and then they will reissue the birth certificate with the birth father on there. Now, okay, so let me be clear about this. I did this all for various reasons, my son, keeping him, but also I never completely closed the door on my ex to his child, right? And that is because of my adoption. How I parent is because of the way that I was adopted, and that what I wanted, and I wish that, even though how horrible my biological father was, I just wanted answers, and I wanted my siblings to know me. And so I really wanted that for my child. I'm not going to go down the whole rabbit hole, but I will say that I think that the way that a lot of us parent is because of our childhood, or because of things that we had gone through, right? That we have lived experience in. And I will say, I feel like a guilty parent. So, and in 1996, sorry, we're going to get back into reading. And in 1996, when my daughter was 19 and ready to search, all states but Alaska and Kansas, which have always allowed adoptees copies of their original birth certificates, once they become of age, continue to deny adoptees knowledge of their identities even after becoming adults. So, by the way, this has changed since 1996. In fact, it's recently changed in recent years. There have been a lot of updates, although there's still many states that are semi-closed or closed. A lot more states are open. And as I was saying before, New York is the only state that has reinstated all of our human rights. Now, I was born in Kansas, so I always had access to my original birth certificate. Your parents can always, your adoptive parents can always ask for another copy. Like I said, I have mine. Does it help sometimes? Sure. I think it would really depend on what information you have, what other records you are able to access, and what you aren't. Do I think that everyone should have access? Absolutely. 100%. Let me say that. And I think it should always be free as well. I don't think that we as adoptees should have to pay. But yeah, there are still states that deny adoptees human rights and knowledge to their identities. They will issue a birth certificate and even black out names, right? Which is, that's not helpful. So anyway, continuing on. Adult adoptees in other 48 states could learn their birth parents' names only through the help of private investigators, search groups, or attorneys, and there was no assurance that any of these would be successful. Not even the lawyers who had to convince judges that the adoptees had good cause for knowledge of their roots. Good cause is a vague term that many judges deemed inapplicable even to grave reasons, such as the need for biologically compatible bone marrow. A Georgia Tan adoptee living in California told me of appearing before a Tennessee judge who ruled that her leukemia was insufficient reason to justify access to her health history. Like, this is freaking ridiculous. I mean, okay, she absolutely should have, but also let's also talk about, sorry, I'm just going to mention this, that when you were applying for was it Social Security, you could be on your deathbed and they will deny it. Right? Like, the way that the system is built is awful. All right, continuing on. The adoptee later discovered that this judge had rubber stamped many of Georgia's illegal transactions. The reason that other judges withhold adoptees' records are hopefully less self-serving than the Tennessee jurists, based solely upon their interpretation of their state's adoption laws. The reason for laws denying adoptees knowledge of their birth names and identities is said by legislators across the country to protect what? That doesn't make sense. To protect all members of the adoption triad, adoptees, birth parents, and adoptive parents. Issuing false birth certificates to adoptees and sealing their true ones protects them, it's claimed, from their traumatic realization that they had been conceived out of wedlock. So first of all, that's bullshit. Actually sealing them and lying to us is not only it takes away one of our human rights according to the Declaration of Human Rights by the United Nations. It causes identity issues, and then we have no access to medical history, genetic mirroring, and yeah. For those that, there are people that claim like, oh, but what about the birth parent that like wants to be hidden? I'm sorry, you openly had a fucking child. The child should always come first. That is your DNA, and this goes for donor conceived too. Let me make this clear. And that's also surrogacy, because there's different types of surrogacy. Don't even get me started on that. They should always know. This is the problem. We don't know, and it's causing more issues. What it's really doing is protecting the adoptive parent. So if the adoptive parent doesn't want to tell the child, the adoptee, that they're adopted, which I've heard by some people, not just late discovery, but they will literally lie about medical information, cultures, race, all these sort of things. Yes, I know. It can be extremely harmful and cause self-identity crisis. And yes, the adoptee will always feel like there's something off, and they will eventually find out. It may be on your deathbed as an adoptive parent, but they will find out. Okay. Maintaining the anonymity of birth mothers is said to help them preserve their privacy and prevent them from being intruded upon years later by the children they relinquished. Adoptive parents are depicted as needing the strongest possible assurance that their children and their birth parents will never meet. Adoptees have long understood the speciousness speculaousness, that's such a weird, it's like chopped up, of these arguments. Most assumed they were born out of wedlock. Few were shocked by that supposition or would be devastated to learn it was true. I'm pretty sure majority of us were, and I, like, frankly, who gives a fuck? Like, honestly, is it really that big of a deal? I know social status, but like, come on. Few single mothers are unduly embarrassed by their status, and 88.5% of birth mothers, according to a study published in 1989, support adult adoptees' access to their birth parents' names. Let's also mention that there are statistics state by state about search, and every state has you gotta look for it, but there's you can put your name on a search list to be found as both a birth parent and as an adoptee. And yeah, they've showed, I believe it was average like 90%, if I'm not mistaken, in our country, that birth mothers specifically, look for their child. Okay, continuing on. Many adoptive parents not only appreciate their children's need to know their origins, but help them search. Okay, so that's more recent, just saying, but like late 80s and on. But Beth was lucky, for although she may never see her original birth certificate, she had long known what I believe was her mother's last name. The word Garvey had been typed in the margin of a court paper sent to my husband Bob and me after the finalization of Beth's adoption in 1978. 18 years later, she procured through the internet the phone numbers and addresses of every Western New York State resident named Garvey. I'm not gonna lie, I did the same thing. Sorry, I'm laughing, but I found, so first of all, I knew my bio mom's full name, right? What I didn't know, and I did look for her off and on over the years. What I found then was one of her brother's names, and I found that he was still living in the state, because one brother moved to California. So this one was still in Kansas, and I called everyone in that area, specifically in like a certain area, right, that they had lived in. I think it was like 4 or 5 people. Like, it wasn't a lot of people, but till I found him, and then that's how I found my birth mom. But I mean, you do what you got to do, right? Like, anyway, she wouldn't call all of them. She didn't want to embarrass her mother by speaking with a relative who might not know she'd relinquished a child. Instead, Beth would seek the help of a local support group, Adoption Network Cleveland, in determining which female Garvey, if any, was her mother, and contact her. I long understood that American adoption is particularly close and secretive, but it wasn't until I began studying Georgia Tann's impact on the institution that I realized that European countries like Germany, England, Scotland, Wales, Belgium, Holland, Sweden, Norway, Denmark, Iceland, and Finland allow adoptees access to their original birth certificates. Australia, New Zealand, provinces of Canada, Israel, Taiwan, China, Japan, and Korea give adoptees access. The United States is one of the few countries that legally forbids adopted adults' knowledge of their birth names. Okay, so I also want to mention that some of these countries also do immigration, right? So immigration is coming in, and I think that's how you say it. Emigration, that's what it is. It's with the E. You are going out of the country. And while there isn't that many, there are adoptees who are born in the U.S. and adopted out. A lot of these countries have also now recently stopped adoption to the U.S., and some of them, like Ireland and South Korea, for example, and Australia, that I can mention off the top of my head, have come out and apologized to adoptees. What are you waiting for, America? Like, let's do, well, I don't have hope in the next few years, but hopefully we will be working on new legislation, whether it's statewide first and then nationwide. We'll figure this out, but there is stuff coming, I promise. It's just, I think federally we kind of have to wait. I hate to say it, there's more important things right now that we should be worrying about than our access to vital records. And that's not to say that it isn't important. It's just, can we get our government back up and running? Anyway, American adoptees have long been furious at being denied a right enjoyed by every other American citizen. Adoptee Caprice East, who, with Denny Glad, headed the Tennessee Coalition for Adoption Reform, pointed out the unfairness. Serial killers can know where they came from, but I can't. Okay, I also want to mention that there are quite a lot of serial killers. And there, God, it's like such a weird statistic. We're not totally sure if this is accurate, so let me make that clear. But it said, okay, I'm not going to cite my sources right now because, again, these sources are questionable, but it is said, rumored, that adoptees make up 15%, was it 15%, or we're 15 times more likely to become serial killers? Yeah. In fact, Lori Carangelo, who we read one of her books already, has a book on adoptee serial killers. 430 serial killers, adoptee serial killers, how and why they did it, I think it's called. Anyway, but she does cite it, and there is some questionable things, but that's a whole conversation I'm not going to get into right now. All right, let's move on. Also, I want to mention Georgia Tann would be classified as a serial killer. Like 50 babies in the span of a few months. Yeah. Okay, that we know of. That's recorded. For decades, Georgia Tann's adoptees and their relatives fought individually to escape her influence and to find their birth families. Then, after finding a sister placed for adoption by Georgia Tann, Memphis Carolyn Mitchell began helping members of other separated families find lost relatives. In 1978, Denny Glad founded Tennessee's The Right to Know, a search group that also fights for adoptees' access to their original birth certificates and adoption records. Throughout the decades, Georgia Tann's indirected victims who, although they never met her, suffered from her legacy of secrecy, have mounted similar campaigns. Their names are well known in adoption circles. Jean Patton, who, after locating her birth mother in 1942, created an organization called Orphan Voyage. And the soul of every adoptee is an internal flame of hope for reunion and reconciliation with those they have lost through private or public disaster, she wrote. Florence Ladden Fisher of New York, who in 1971 founded the Adoptees Liberty Movement Association, ALMA, which now has branches across the country, and called with holding birth information from adoptees an affront to human dignity. Betty Jean Lifton, also of New York City, whose 1998 memoir, Twice Born, Memoirs of an Adopted Daughter, eloquently espouses adoptees' right to knowledge. And there are countless other adoptees who describe the blankness regarding their past as a constant gnawing. It creates a hole that can't be filled, a vacuum for which there is no substitute. It is a piece of my soul that is gone. Not knowing who they are is like being a jigsaw puzzle with pieces missing, the center of a wheel missing two spokes. No one has the power to deny me my birthright. Ooh, that is a good quote. Anyway, fairness alone would seem to dictate that adoptees should be allowed to know who bore them. But most Americans, including me, had long assumed that the falsification of adoptees' birth records had at least sprung from the motives of well-meaning social workers anxious to relieve adoptees of the stigma of illegitimacy. Typical was the reasoning of the author of a popular book on adoption published in 1940, who wrote that withholding information about adoptees would help prevent reporters nosing about for news, coming upon something really juicy and publishing it, causing untold suffering and permanent damage. Unscrupulous birth relatives could trace a child if they wished, and use their knowledge to upset a well-established adoptive relationship. The same rationale had been expressed several years earlier, however, by someone less well-meaning. In 1937, a letter to her attorney, Abe Walder, Georgia Tann justified her refusal to tell the Tennessee Department of Public Welfare or the Departments of Public Welfare in other states anything about her children, including their birth names. Disclosing information, she wrote, would result in adoptive information being leaked to social workers in the counties where the adoptive parents lived, and the child's adoption becoming a very tempting morsel of gossip. Georgia's attorney was as dedicated as she is to secrecy and adoption, not only out of disinclination for providing food for gossip, but, as Abe wrote her on April 25, 1940, to avoid placing an effective instrument of blackmail in the hands of an unscrupulous birth parents and opening the way for them to pry upon real adoptive parents whose fine impulses have impelled them to accept children for adoption. That's a mouthful. Basically, they're saying that the birth parent will blackmail the adoptive parents, aka the real parents, as they put them in this, as Abe put them. Yeah. Needless to say, departments of public welfare in states across the country, including Tennessee, resented being denied information about the children Georgia placed with local citizens. And in 1944, a Tennessee adoption law was proposed that would have made her adoptions less secretive. On October 6, 1944, Abe Walder wrote on Georgia's behalf to the chairman of the Committee on Social Legislation in Nashville. The proposed statute regarding adoption is atrocious and should not be accepted. We object to the requirement of Section 1 that the adoption petition must be filed in the county where the adoptive parents reside. In order to secure the position of adopting children, anonymity is essential. The first place a birth parent would look in seeking to find a child would be in the records of the county of residence of the adoptive parents. Section 3, requiring natural parents to be made defendants, i.e., informed that their child was being adopted, is contrary to all advanced thinking of correct social service. This places in the hands of the real birth parents of the child an effective instrument of blackmail. Only backward states require service of process on the real parents of the child. The proposed reform law, he continued, is just an attempt to make adoptions difficult and to surround the entire procedure with the sort of intrusive inquisitiveness of social workers that will have the effect of reducing adoptions in Tennessee. We are unalterably opposed to the State Department of Public Welfare becoming an investigative agency of this character. This would inject the State Department into adoptions, and would mean that information respecting adoptions would be available as choice morsels of gossip for inquisitive women in a political setup. Okay, so basically, on behalf of Georgia, Abe is saying, her lawyer is saying, we don't like this. We are not going to abide by this. We continue to want secrecy because the family will be blackmailed if people find out. And what you guys want is not only oversight, which will reduce adoptions, but will then quote unquote harm the adoptive parents, according to this. I think really what they wanted was not to be caught in their scheme of harm, but it is what it is. Can't go back in time and undo it, because if we could, we would, but all right, continuing on. A desire to cater to adoptive parents anxious to prevent their children's birth parents from finding their children wasn't the only reason Georgia kept her adoption secret, but it was a large one. We never tell the natural birth mother or reveal to others where the child is or where it is being placed for adoption. Notice how she says it, like, ugh. Anyway, Georgia told a reporter for the Commercial Appeal in 1948, adoptive parents want to take the children and love them as their own, and they do not wish to be subject later to interference and confusion. But while Georgia refused to let birth mothers know who had adopted their children, she frequently let adoptive parents know whose children they'd adopted by giving them adoption decrees that listed the name of the child's birth mother. She may have done this to satisfy adoptive parents' curiosity, and she apparently wasn't worried that her clients would share this information with their adopted children, leading to an adoptee and birth mother reunion. That might lead to exposure of her child's genome. Okay, so before we continue on, I'm going to guess that because we know that she falsified a lot of paperwork, she probably didn't even put the accurate birth mother's name. Just saying, like, I can just see that. She was correct in her assumption. Most adoptive parents of the time were as loath to have their children find their birth parents as they were to have the birth parents find their child. In an attempt to prevent the child searching, many adoptive parents didn't even tell adopted children that they'd been adopted. I know of only 4 Georgia Tann clients who gave their children information about their backgrounds. 3 did it out of kindness. The other was Joy Barner's adoptive father. After telling her, I paid $500 for you and I could have gotten a good hunting dog for a lot less. He threw her adoption papers at her feet, shouting, You come from the lowest scum on earth. So first of all, not only is that financial abuse, that's mental and emotional abuse, and utterly disgusting. Adoptive parent, oh God, I'm going to say this as kindly as possible. Adoptive parents and hopeful adoptive parents often talk about the price of adoption, not realizing that it puts a price on the child, right? And when we find these records, which by the way, I have found a meticulous account of how much my adoptive parents have spent for me. Shouldn't laugh, but it's ridiculous. It's like, yeah, I spent $20,000 to purchase you, right? Like, that money could have been spent to help keep a family together, right? That $20,000 could have helped my birth mother move out of the trailer to a different place to raise me. It would have helped her with food. It would have helped her with rent. It would have helped her get back on her feet. Instead, she was suffering and ended up in a psych ward after. There's, yeah. Like, and I'm just saying my case, right? But, like, I'm not saying 500 would do that, but, like, let's just be honest. Like, when they're talking about it, they don't realize how harmful it is, right? When we see those things, and they're like, oh, it should have been cheaper. Oh, it should be easier. And we're like, no, like, first of all, majority of adoptive parents should not be adoptive parents. Let's talk about that. But also, we are not meant to, maternal separation really should not happen unless absolutely necessary due to neglect, right? And sometimes it's a temporary thing, sometimes it's long term. Every situation is different, but adoptive parents really, let me say this, they're basically told, oh, this is the way that you can, like, grow a family. Like, oh, you're infertile, like, you could just adopt. Or, oh, you happen to be a gay couple, like, you could do this. Same thing with donor conceived, same thing with surrogacy, right? Like, I don't want to say none of it's natural, because it's not, but that's not the way I'm thinking about it. I'm thinking about it in what's in the best interest of the child. That doesn't mean that you are automatically a horrible parent. However, I will look at you differently because I feel like there's selfishness. You were so selfish to want a baby that you adopted, right? Or you were so selfish to want a baby you did donor conceived, and I'm talking like through the banks, right? Not like a friend that you know that there's that way, right? That is the way that I personally look at it. It just gets really icky and not child-centered at all. Okay. Contemporary adoptive parents like Bob and me are also often given the names of their adopted child's birth parents. There have been no studies of how frequently this happens or of why it occurs. But the fact that adoptive parents are sometimes given birth parents' names, and that, except in cases of open adoption, birth parents are never given the names of adoptive parents, indicates which party courts and some adoption agencies consider important. This continues to be the party Georgia favored, the adoptive parents. Today's adoptive parents, however, are more likely to give their adopted children their birth parents' names. Of course, Georgia and her lawyer had... Wait, what? Did we read that part. Sorry. Didn't we? Yeah, Sorry, guys, hold on. I just lost where I was. It, like... Oh, okay. It just re-quoted something, that's all. That's why I was confused. Never mind. Let's continue. Of course, Georgia and her lawyer had reasons for secrecy, other than to placate and coddle adoptive parents. To a great extent, Georgia operated in plain sight, but absolute openness regarding her adoption practices, which would have been tantamount to an admission of kidnapping, would have taxed even Boss Crump's tolerance. Georgia and her attorneys' need for concealment was so specific that their argument that openness would provide, quote, an effective instrument of blackmail might never have been used again. But over 5 decades later, in 1996, a lawyer defending secrecy in adoption paraphrased Abe Waldor's words. Openness could be easily used as blackmail or the threat of blackmail. The use of wording so similar to Georgia was no coincidence, but rather evidence of the endurance of her legacy of secrecy in adoption. And we have continued to deal with this, right? So she's talking about 1996 and hearing this, right? Something like that. Yeah, she was talking about hearing this in 1996. We are now about 30 years later, right? And we still hear people think that, and I want to say not usually adoptees. Some adoptees will be like, oh, well, I don't want the information. And that's cool. Like I said, every adoptee is going to be different. Having access to it is what's important, right? Not just access, but like actual access. Not just the opening, but like, do we have to pay money and how much, right? I was talking to someone the other day and she was saying that she needed something and it was going to cost her over $500 at Vital Records to get the information. And it's like, how not a lot of people have that extra money, especially these days, to do that, right? Crazy. Anyway, where were we? Considering her general proclivity for deception, her need to cover her tracks, and her energy, it was perhaps inevitable that she would be the person to begin the practice of falsifying adoptees' birth certificates. What is remarkable is that until I began my research, neither I nor anyone else knew that she had originated this identity theft. One reason for this, of course, is her escape from historical notice. Another is that the first state to pass a law amending adoptees' birth certificates in 1931 was Alabama, not Tennessee. Adoptees and their advocates, however, have long suspected a link between falsified birth certificates and baby selling. Secrecy in adoption does cover a multitude of crimes, Hal Agner wrote in an Adoption in America Coming of Age, published in 1992. Hold on. I'm going to highlight that so we can get back to that. Okay. The instincts of adoptees and their advocates are correct. In 1928, 3 years before the passage of the Alabama law calling for the amendment of adoptees' birth certificates, Georgia Tann had extra legally begun having the Tennessee Department of Vital Statistics issue phony birth certificates for her adoptees. 9 years later, in 1937, she used her political connections to have a law passed legalizing the practice in Tennessee. Within 20 years, all 48 states were issuing adoptees falsified birth certificates, and upon admission of Alaska and Hawaii as states, the number rose to 50. And in the vast majority of states, legislators and social workers denied adoptees knowledge of their identities forever, for far longer than they did when states first began falsifying birth certificates. Georgia's inducement of legislators and social workers across the country into becoming almost as secretive as she was is one of her most terrible and extraordinary accomplishments, one that required her, once again, to stand previous adoption practice on its head. Until her influence upon adoption hardened in the late 1950s, the prevailing theme regarding it was one of openness. Despite the falsification of adoptees' birth certificates, almost all adult adoptees but Georgia's were given information that would help them find their parents. They were given this information by reputable social workers who understood the importance of family ties. As late as 1946, the supervisor of the State Charities Aid Association of New York stressed, "The identity of a child is his sacred right, and he should not be deprived of it," a sentiment shared by the Child Welfare League of America. Established in 1921, the League had quickly become the most renowned national organization of child welfare agencies. In the 1930s, the League formulated adoption standards protecting all members of the adoption triad and emphasizing the rights of adopted children to know their roots. By publicizing these standards, the League hoped to curtail the practices of the many unregulated adoption arrangers who were capitalizing upon adoption's sunrise in popularity. Okay, I want to make this clear. Unregulated still happens, and majority are. There is actually a list via the government. I forgot what the exact website is. I'll do a whole video on this, of which agencies are actually regulated and which are not. And those that are regulated are now subject to IRS investigations under a new law that passed pretty recently. I can't remember the name of it, but anyway, it was a really, really good law. And it was saying that a good percentage of that profit that they make will be going to programs to help with reunification, kinship, and ICWA, the Indian Child Welfare Act. So I do want to make it clear that there are some good things happening. Still, we just I just think that we don't talk enough about it, but also like the history of all this is also important. So, yeah. Okay. Where were we? Some of these arrangers were well-meaning but lacked training in arranging adoptions. The league's executive director, Charles C. Carstens, was particularly disturbed by the lawyers, doctors, and others who profited financially from adoption. One of these black market arrangers, of course, was Georgia Tann, but Carstens was unaware of her unethical practices until 1936, when he began the investigation that culminated in her agency's expulsion from the League for advertising children in newspapers and failing to properly assess qualifications of adoptive parents. And since neither he nor most of their other social workers outside Tennessee knew that she stole and sold children, they also didn't know that she falsified birth certificates, in part to cover her crimes. But her purported reason to spare adoptees the embarrassment occasioned by the letters OW, out of wedlock, or the word illegitimate must have sounded good. Why, indeed, reputable social workers had long wondered, should adoptees be stigmatized by birth certificates highlighting their out-of-wedlock status? By 1920, laws forbidding the inclusion of this fact had been passed in Minnesota and New York. But these don't solve the problem, since adoptees' birth certificates, which often included the names only of their mothers, not their fathers, continued to imply their status. Ethical social workers in several states considered eliminating all information but babies' names on birth certificates, but determined that birth parents' names had to be included for historical purposes. Georgia's practice of issuing amended birth certificates that portrayed adoptees' adoptive parents as their biological parents seemed the perfect solution to a long-standing one. But while ethical professionals supported state laws that falsified birth certificates and kept the original ones confidential, they interpreted the word confidential differently. From Georgia, she kept original birth certificates secret even from her adoptees. Ethical social workers and vital statisticians who wished only to keep adoptees' origins from the prying eyes of reporters and the neighbors allowed adoptees copies of their original birth certificates. Workers like Maud Morlock, consultant in the services for unmarried mothers for the U.S. Children's Bureau, stressed the importance of giving adoptees information about their past, for every person has a right to know who he is and who their parents are. Throughout most of the 1940s, the Child Welfare League of America and other prominent social service organizations understood and sympathized with adoptees' need to search. Many adoption agencies helped adoptees find their parents. Then everything changed. Ethical agencies of evolution, from the sharing of information with adult adoptees to the secretiveness practiced by Georgia, was gradual enough to make identifying the date of its change difficult. But by 1960, virtually all social workers denied adoptees information that would help them find their families. Georgia's role in corrupting virtually all American adoption with secrecy was less direct than were her roles in popularizing the institution, commercializing it, and forcing single mothers to relinquish their babies. She couldn't coerce social workers outside Tennessee through blackmail, as she had the Memphis workers she had provided with adopted babies, and had controlled ever after by threatening to reclaim the children. She couldn't threaten to ruin the reputations of ethical social workers, as she'd done with the rural single mothers she silenced by threatening to accuse them of promiscuity to everyone in their hometowns. But she could, by existence and those of her imitators, force ethical social workers to make a terrible choice. In 1955 and 1956, Senate subcommittee hearings were held that focused upon illegal adoption practices in an ultimately futile attempt to secure passage of a federal law against baby selling. The hearings were chaired by the U.S. Senator from Tennessee, Estes Cavero, one of the political outsiders who, in 1948, had been instrumental in Trump's statewide fall from power, which in turn led to the unmasking of Georgia Tann. Her crimes had in fact inspired Cavero's Washington efforts. When I had first read the Senator hearings transcript, I'd concentrated on former investigator Robert Taylor's deposition regarding the deceased Georgia Tann. But once I began seeking a reason for ethical social workers' reversal, I recalled testimony regarding black market adoption arrangers who were then still alive. Although they operated on a small scale, they didn't usually steal children, but instead coerced parents into relinquishing them. They profited financially from adoption. The Cavalfer Committee studied the tactics of brokers who had begun operating after Georgia and were clearly following her lead. A team very similar to that of Georgia and juvenile court Camille Kelly worked in Augusta, Georgia, where a probation officer reported the names of babies born to poor parents to a juvenile court judge who terminated the rights of the birth parents. The two then sold the children to couples in California and New York. The probation officer, Elizabeth B. Hamilton, acquired some newborns by telling mothers their babies had been stillborn. Another baby seller, operating in Wichita, Kansas, kept pregnant women on cots in her basement and allowed clients to choose the women whose child they would buy. Runners, who scouted single pregnant women, operated in cities like Chicago. The runners worked for brokers who paid young women small fees for their children. One scout frequented a parking lot used by truckers from all over the country, asking, "Is there any babes you know that are in trouble that I could take over and give them a few bucks?" Operators of a Fort Worth, Texas maternity home fed pregnant women little but cake and water and tricked them into relinquishing their children. If their babies had physical or intellectual problems, however, the mothers were enjoined to raise them. One young woman testifying before the committee pointed out the irony that she was considered unqualified to raise a non-disabled child, but capable of raising a disabled one who might require greater care. The committee also heard testimony regarding less organized ad hoc transactions, such as that of the father in Long Beach, California, who traded his unborn daughter for a poker deck. Ew. I really hope that these people went to jail for all this. A Chicago woman sold her baby to a milkman for $1. An undercover social worker in New Orleans paid a midwife $30 for an infant girl and received a baby boy as bonus. A child was sold twice during a train ride from Los Angeles to El Paso. Oh, God. Fewer than 1/3 of the estimated 75,000 adoptions that occurred in the United States in 1949 were handled by accredited agencies. Let's also remember Barbara Raymond, the author, had noted that Georgia Tann was not an accredited agent, right? She did everything, she could have done everything fairly legally, but she chose not to. Okay. I recalled reading articles printed in the 1950s in the popular press in which reputable social workers agonized over how to keep children from falling into the hands of baby sellers. I recalled their conclusions that of Ernest Mittler, special counsel to Cavero's subcommittee, who investigated black market placements in New York City, Chicago, Duluth, Minnesota, Norman, Oklahoma, Texarkana, Texas, and Montreal, Canada. Ethical workers, these experts agreed, had to persuade the independent brokers, adult victims, single mothers, and the brokers' customers, adoptive parents, to work with reputable agencies. Doing so required understanding why so many pregnant women and adoptive parents worked with brokers. The reasons were self-evident. Pregnant women who relinquished their children through legitimate agencies were responsible for their pregnancies pregnancy-related medical and living expenses. Unmarried women availing themselves of the services of independent operators and baby sellers received free room, board, and medical care. Okay, I want to also mention that a lot of these pregnant women actually ended up getting WIC and getting Medicaid. So there was other things to that. So it's not just like, oh yeah, you get free room, board, and food, right? Like, that's not really how that worked out. They couldn't also just change their mind. Like, it was a lot of coercion and manipulation. All right, continuing on. To Catherine B. Oettinger, head of the Children's Bureau, the repercussions were obvious. The unmistakable fact is that the unwed mother needs help. And until she can get it, the black and gray market placements of children for adoption will continue, she wrote in 1958. 10 years earlier, the prescient social worker Leontine Young had told her colleagues, because we cannot give adequate service to the unwed mother, we do not have enough children to place for adoption. Because we do not have enough children to place for adoption, the public grows impatient and ignores us. Caught between public prejudice and ignorance about the unwed mother and public demand for adoptable children, we can protect neither the unwed mother nor the child. Ooh. The black market steps in without the knowledge or scruples to fill the vacuum we have not. Again, so they're talking about a market, right? Supply and demand. The demand is the babies. The supply is the unwed mothers, the pregnant unwed mothers about to give birth, right? And they're treating the baby, the child, the adoptee, like a product. And the black market operators were fast. According to the Kavar Committee, they approached some pregnant young women within 5 minutes of their arrival in a new town. Black market operators also served prospective adoptive parents quickly and with little red tape, practices that were greatly appreciated. Some clients wouldn't have met the requirements of more careful agencies, and many were comforted by the secretiveness common among black market transactions, of which few records were kept. Okay, this still happens, but instead of doing domestic infant adoption, they end up doing international adoption sometimes. Not only is it cheaper, but there are very questionable agencies. Like I said, a lot of these adoptive parents should never have been adoptive parents. Should never have been parents, period. But yeah. Okay. Threatened by the prospect of their children's reunion with their birth parents, few adoptive parents realized they might feel secure enough to want to help their children find their roots. Ethical social workers' concerns weren't entirely altruistic. Some feared that brokers would force them out of business or sully the reputations of all social workers. But their main concern was preventing children from being exploited and sold. Ethical professionals could conceive of only one way of competing with the baby sellers, by imitating them. Ernest Mittler, special counsel for Kavar subcommittee, suggested that cities adopt the Washington Plan, begun by the Washington Children's Home Society in Seattle in 1949. Disturbed by the success of unethical owners of maternity homes, whose newspaper ads seemed like a beam from heaven to desperate, financially strapped young women, the home ran its own ad, maternity care for unmarried mothers, including doctor's hospital and living arrangement. The Washington home induced 14 doctors to work for nominal fees and 2 hospitals to make special arrangements. And a girl can stay home, board out, or live in a private home where she is paid for easy work, Mittler wrote in an article for Look magazine. By 1953, the agency had handled 103 cases from 20 states, and the unethical maternity homes in Seattle had closed. Social workers in many other areas continued to be hobbled by lack of funding and by state laws that frequently required 1-year residency for single pregnant women needing financial help. But the Travelers Aid Society managed to get more flexible treatment of non-resident mothers in Texas, and the funds other than those already afforded by aid to dependent children became available for the medical expenses of unmarried women in Northern California and other areas. Ethical social workers also began streamlining their services to pregnant women, allowing them to be followed by a single worker throughout their pregnancy, rather than making them work with several different people. To lure away black customers, social workers streamlined services to prospective adoptive parents too, easing restrictive requirements regarding age and religion. And to mollify adoptive parents fearful of losing their children to birth parents, social workers began refusing to give adult adoptees information about their roots. To save children, ethical social workers denied them their past. To help them, they hurt them. That's right, they did hurt them. They hurt all of us. Ethical social workers didn't always own up to their capitulation, their rationalization that keeping adoptees' identities secrets allowed them to make a clean break with their past. Secrecy protected adoptive parents from intrusion by birth relatives, they said, and protected the privacy of single mothers. Some reputable social workers, however, understood the hollowness of these excuses. Annette Barron and Reuben Pinar began their careers in social work in California in the late 1940s. They were then unaware of Georgia's influence upon adoption, which may have been particularly strong near Los Angeles, the site of her sole branch office of an organization called Adopted Children's Association. Composed of 1,000 parents who had adopted through Georgia, the Adopted Children's Association was headed by Mrs. Ernest Debs, the wife of a prominent state legislator. During the 1940s, Georgia persuaded Mrs. Debs to chair a committee that rewrote California adoption law. Georgia also addressed the California legislator herself. Passed in 1949, the new law required California courts to recognize the decisions of Tennessee courts regarding adoptions, and made the relinquishment of birth mothers immediately binding. Formally, California mothers had had a period of time before their children's adoption during which they could reclaim them. The new law reduced the rights of birth parents in California to the level of those in Tennessee, virtually none at all. Georgia Tann died 1 year after the passage of the California law, but Annette Barron and Reuben Pinar and thousands of other social workers began their careers in environments heavy with her legacy. I bought into the whole system, Annette Barron told me. I believed closed adoption worked. I accepted that a social worker's effectiveness was measured by how many unmarried mothers she could persuade to surrender their children, that the goal was to persuade all of them to give their children up. I also believed mothers could go on with their lives as if nothing had happened, and that normal, healthy adoptees would have no curiosity about their roots. Through the years, however, these supposed truisms rang more and more hollow. In 1979, 21-year-old man who had been adopted through Annette's agency said, "I don't expect you to give me any information, but could you call my birth father and ask if he's willing to meet me?" "No one had ever asked me that," said Barron, but the young man was reasonable and intelligent, nothing like the then supposed sick and obsessed searcher. His request made sense, she said shortly afterward. She hosted a seminar titled, "Is Anonymity an adoption necessary, and began research which led to the publication in 1978 of a book by her, Ruben Pinar, and Arthur Soroski called The Adoption Triangle, which, by the way, we will eventually get to. It was a groundbreaking event that sparked the adoption rights movement. But by the 1970s, the secretiveness Georgia had insinuated into adoption was well entrenched. Virtually no adoptees were allowed knowledge of their origins. Doesn't this remind anyone of how we treated slaves? Asked an adoptee in a letter to the New York Times. Like I said, there are many adoptees who equate adoption to slavery. Sometimes the treatment, the lack of human rights, and so much more. Like I said, I personally would not, but I also don't fault those who do. I will say that it 100% is human trafficking. Even in the best case scenario, right? Even in, when I say best case scenario, even when a child must be removed for safety purposes, and I mean like actual neglect, adoption still takes away human rights, and that's why I preach, at least I hope that people are understanding that when I say that there are better options for safe external care, those also need reform, right? And so it's also important to listen to those with that lived experience, because it's not a one size fits all. There is a lot of things that, as I was saying before, there's a lot of things that should be passed that maybe not everyone is going to take advantage of, and that's okay. As I was saying, there's some adoptees that don't care to access their records at all. Again, totally fine. Does that mean that all adoptees should not have access? Of course not. So there's some adoptees that want to annul their adoption. There's some adoptees that don't. There's some adoptees that change their name or want to change their name back to their original. Totally okay, right? Does that apply to everyone? Of course not. Should we have access to that? Should we make it easier? In my opinion, again, yes. I'm not going to hold back for those that want that. I will completely advocate for those that are asking for it. That being said, I will see you tomorrow for chapter 13. We are just about done with this book finally. And I don't say that in a bad way. I just mean, I just have a ton of things that are going on, that I need to do. So we'll start something new come November. I got to figure things out, but let me just finish this book this week and then we'll figure out the next step. All right, see you guys.